SwayamPrabha. Digital India. Educated India.
Hello viewers, this is Dr. Ashwini Sival from Faculty of Law, University of Delhi. I am here to discuss very important topic, that is Internet and Law. This topic is in the series Law, Science and Technology. This is lecture number 20 of this series. Viewers, in the preceding lectures we have seen as to how technological developments or scientific developments posed a very great challenge to the lawmakers across the globe. We have also discussed and seen in the preceding discussions and previous lectures how different disruptive technologies or exponential technologies are posing a challenge to the lawmakers or to the legislative developments across the globe, especially the AI or other such developments or disruptive technologies which have proliferated over the period of time, and in the recent past we have witnessed that AI is ubiquitous, it is everywhere, it is omnipresent in almost all the smart devices. AI is being used, or usage of such other devices, AI enabled devices I mean, is very rampant. Now in today's discussion, friends, we are going to discuss Internet and Law, and well, you all understand that Internet is a medium which is very vast, which has no boundaries, which has no territorial restrictions, and it works in myriad ways or in various ways. There are different usages or uses of Internet. We can't just sum up it in one or two particular uses of Internet or in three uses of the Internet. Internet is a medium which is used for commerce, which is used for communication, which is used for these days for even disrupting the democratic setups. It is being used for dissemination of the information, it is being used for initiating the warfares, it is being used for espionage, it is being used for surveillance and what not. There are umpteen number of usages of the Internet, some are good, some are bad. We know that it comes with certain advantages, but detriments or the disadvantages that are attached or associated with Internet are also manifold. So our purpose in today's class or in today's topic is to understand what are the legislative measures or the laws prevailing in India as well as in other jurisdictions to regulate this unfettered medium called Internet. I am aware that it is not easy to regulate properly this medium because it is vast, it has some such features which cannot be so well regulated, like anonymity, like no territories or no restrictions in terms of territory, and its operation is very expeditious, right, and it is cheaper also nowadays. But notwithstanding that, it is regulated or it is tried to be regulated by different legislative responses in India as well as in international domain. We will see in today's discussion what are those responses and what are those legislative and regulatory frameworks which are there, which are in operation or which are operational for the purposes of tackling this menace, or you may say for the purposes of tackling this boon, right. Let us start. Viewers, let me give you just a small idea as to what Internet is all about and what are the different issues that may arise, that may crop up on Internet or while using the internet. The very first slide gives you so many varied important issues, or the glimpse to so many important issues like consumer protection, national security, freedom, deep fakes, cryptocurrency, governance, online trading, crimes, data protection, privacy, e-commerce and online gambling and whatnot. All these things fall under the ambit of the internet, or may happen under the ambit of the internet. So, we will have to look all these, or at least few of these things, and the legislative response towards these things, towards these activities basically of internet or on internet in the Indian context as well as in the international context. So, in my today's class I will be covering certain important topics. I will be introducing the concept of internet and law, then I will be focusing on internet and intellectual property laws, internet and competition law. Then we will also have a look, very quick glance at data privacy, Digital Personal Data Protection Act of 2023, since it is recent. So, we must look at it also, and then our major emphasis shall be on information security management systems for data security, and then some fair information practices to be followed or to be complied with, and then we will also have a look at the recent 2021 rules on intermediaries quickly. Then our our attempt will be also to cover the European Union laws pertaining to internet or its regulation, as well as US laws pertaining to internet and its regulation, and then few judgments we will consider or we will look at to understand more about this complex issue called internet and law, right. So, let us start with the introduction. Viewers, as you all know that increasing reliance on digital solutions and cross sector interconnectivity, coupled with the emergence of transnational security threats originating from cyberspace, has prompted nations across the globe to respond with various initiatives for bolstering its comprehensive cyber defense strategy aimed to protect, detect, defend and deter against cyber attacks and ancillary challenges posed by the frontier technologies and internet. So, this the increasing reliance on digital solutions and cross sector interconnectivity, and this is coupled with the emergence of transnational security threats which are originating or which are lying in the cyberspace. These has prompted the nation states across the globe to respond with few initiatives in the form of laws, guidelines, some regulatory frameworks. So, the law on internet may not be just a piece of legislation, it may not be just a piece of legislation, it rather includes laws, guidelines as well as a regulatory framework, right, as well as a regulatory framework, and it together, all of these together may constitute the law pertaining to internet or some regulatory framework pertaining to internet. It cannot be just one simple piece of legislation which can govern this vast medium called internet or this complex medium called internet, because it is posing threat to the national security, it is facilitating consumers, it is facilitating commerce, it is facilitating trade, it is also facilitating communication in a very expeditious manner. So are the challenges prevailing on this medium. So, that is why there cannot be one set of or one piece of legislation which can answer or which may perhaps cater or address all the concerns and all the complexities on internet or prevailing on internet. So, we need a robust comprehensive mechanism including laws, regulatory frameworks as well as some guidelines, right. So, nation states have been prompted, or you may say they were prompted as well as kind of compelled to bring such frameworks into their domestic territories for the purposes of catering to the for the purposes of addressing the concerns prevailing on the internet, right. Now, emerging technologies, especially the frontier technologies and converging technologies, these are the terms which are used interchangeably, to cover the emergence and convergence of new and potentially disruptive technologies, right, such as nanotechnology, biotechnology, cognitive science, robotics and AI in the age of internet. So, we see that these emerging frontier and converging technologies, they all can be used interchangeably, and they are bringing potential disruptive technologies such as nanotech, biotech and cognitive science and AI in the age of internet. With the advent of these things, with the advent of these disruptive, or you may say with the advent of these emerging technologies, internet or the issues on internet have become more complex or are becoming more complex day by day, and the answer to those complex issues are not being made available by one law or one particular piece of a guideline. It requires continuous efforts on the part of the policy makers as well as the lawmakers to address the concerns in light of the advent of these new technologies, which are disruptive, which are exponential in nature, evolving every now and then. Now, there are divergent views available so far as regulations pertaining to internet are concerned and its behavior is concerned. Let us have a look. Many writers, including computer scientist Bill Joy, have identified clusters of technologies in this age of internet that they consider critical to humanity's future. Advocates of the benefits of technological change typically see emerging and converging technologies as offering hope for the betterment of human condition. Right. Some writers and some thinkers of internet, scholars of internet and law, they see that these disruptive technologies or the exponential technologies are basically resulting into betterment of the human condition, right. However, critics of the risks of technological change and even some advocates such as transhumanist philosopher Nick Bostrom warn that some of these technologies could pose dangers, perhaps even contribute to the extinction of humanity itself. That is, some of them could involve existential risks, right. So, some are threatening or opining that these technologies could pose lot of dangers, perhaps contribute to the extinction of the humanity itself. And when these disruptive technologies are clubbed with, or when they are clubbed with the internet, right, they pose more severe risks, or more, you may say, they become more threatening in nature, more apprehensive in nature, and they even lead to existential risk of the society. Much ethical debate centers on issues of disruptive justice in allocating access to beneficial forms of technology. Some thinkers such as environmental ethicist Bill McBin oppose the continuing development of advanced technology, partly out of fear that its benefits will be distributed unequally in ways that could worsen the plight of the poor. So, some thinkers who are against the prevalence or against the proliferation or the meteoric rise of the internet are threatening that it will result into uneven society or unequal distribution, and it will worsen the plight of the poor in the years to come. Then we have by contrast some thinkers who opine and believe that emerging and converging technologies could and will eliminate poverty and abolish suffering. Internet is a path breaking technological development which allows to operate and advertise across all frontiers and borders. Many companies offer various policies and schemes across the world throughout internet. We all know that these days the emphasis is on governance, that is e-governance, right. There is a lot of emphasis on e-governance. Every state scheme or every welfare scheme is made available even to the poor people or people living in the far flung areas in the country. Those schemes, those benefits, those welfare schemes are made available to the people through internet, and so far the experience has been good. So far there definitely has occurred some some wrong instances or some problematic instances, but one particular instance or few instances must not malign the entire utility of the one particular medium. I am of the opinion that e-governance or other such means or mediums to through which the poor may be uplifted or their sufferings may be elevated, such mediums should be promoted and should not be curbed or curtailed. So, I personally believe, and I have myself seen the technological solutions which are actually beneficial for the poor as well as for the rich of the country equally, and there rarely occurs any unevenness or some discrimination, but yet there may be some instances as opined or as propounded by some of the scholars or as discussed by some of the scholars, but this alone cannot be just be final thing, because there lies dearth of the empirical studies on this particular aspect. There lies a great shortcoming or a dearth of evidence based research on these aspects. These at times are political rhetorics to malign the image of the governing ruling party, right. So, coming to next thing that further explains this divergent views or the divide. The main aim of the internet law is to harmonize the existing cyberspace. The cost of worldwide transaction should be reduced by issuing inconsistency and uncertainties arising out of the difference in national laws. Many companies are expanding its business with great speed. With the development and increase in internet and electronic based trading system, the existing laws are getting affected. The traditional legal systems are facing difficulty in keeping pace with the growth of internet and its impact. This is very valid and important finding that the lawmakers are finding it difficult to regulate the internet with efficiency, because of the fact that people are expanding their businesses with a very great speed on internet, and trading, or for that matter commerce, or for that matter communication, or for that matter dissemination of any other thing on internet is rapidly increasing and exponentially increasing. So, traditional legal systems are required to be replaced. They are required to be replaced with the modern legal system, equipped with equipped with the adequate provisions, as well as equipped with the holistic idea of catering to the concerns arising out of the internet, or for that matter arising out of the activities that take place of the internet, right. So, who can use the internet? We all know that in today's world, anybody who has a smartphone, and our country has seen in the recent past a meteoric rise in the uses of the computing devices, the portable computing devices that are called cell phones or mobiles, and people are using internet because it has been made accessible to the people at a very cheaper cost, and or you may say at no cost. So, computer or for that matter access to the computer network has become easier, or through mobile phones it has been made easier. So, internet basically is very much accessible and affordable these days. It can be used by any person at any place. Internet is also used for getting more information using various tools which are used to find out various resources on World Wide Web. The research work using internet can be made in just few minutes or hours. Through internet, a person can also get knowledge of business world. One can also avail services like shopping, entertainment, banking, multimedia, and what not, right. So, everything is becoming available at an affordable price on internet, right. Now, there are myriad functions of internet which we can quickly look at. The main role of internet nowadays is e-commerce. Why I have just mentioned e-commerce? Because I see that the e-commerce is increasing day by day. Even through internet the digital payments are increasing day by day, the trade is increasing day by day. So, commercial transactions are taking place electronically on internet, right, at a very rapid pace. It includes a lot of other things like contracts are being made or broken on internet, infringements are taking place on internet, right. Parties make contract on computers, signatures are put by parties on computers, which is known as digital signatures. And if there is a breach of contract, the question of jurisdiction or law relating to breach of contract is regulated by cyber laws. So, our cyber law also have a answer to the dispute pertaining to jurisdiction of the battles being fought between the countries as well as inter-country. So, cyberspace jurisdiction is a very explicit law, and it is very clear law. As far as our country is concerned, we have good jurisprudence available on cyberspace jurisdiction. Buying and selling is also made easier. The persons doing shopping using internet are needed to be regulated by law. They do shopping using credit cards. The domain names of various sites are almost same, which creates confusion in minds of consumers. Example is reddit.com and rediff.com. So, this is a particular domain name dispute, or you may say particularly a matter which will go to the ICANN, as well as it may be taken to the court of a civil jurisdiction pertaining to trademark dispute, because domain names are as good as trade names in the virtual space, right. So, this needs to be regulated, and our courts have held that these domain names should be used by original owner. Further, publishing, copying or transmitting the work of author is violation of copyright, and downloading the work in any form, that is printing, photocopying, is also in violation, and it also needs to be regulated by law. So, a lot of people are using internet these days and publishing things on internet, even on the social media handles. They are posting stuff, even they are posting the audio visual content, right, and photographs, paintings, their opinions, their literary works. So, everything has the potential or vulnerability of being breached, or you may say copyright infringement may occur. So, there should be some regulations or some laws. Our copyright law very well addresses it. I will explain it later. Then email is another another way in which any misuse of cyber transaction may happen, and it results into violation. There are certain crimes which are done through email, like phishing, or for that matter extortion, right, in the cyberspace. All these things are happening at these days through emails. Banking and advertising is another thing or another use of the internet. These are just illustrative, these are not exhaustive, because there may be several other ways in which an internet can be used and may be used. Now, let me come quickly to the copyright and internet. Well, I told you that publishing a photograph, painting, publishing for that matter any literary work, publishing any cine work, be it a small or a lengthy work for that matter, or any audio visual recording, right. These things, or even downloading and storing electronic copy of anyone's copyrighted work, may tantamount to infringement of the copyright. It may tantamount to infringement of the copyright. So, we have a lot of provisions under the copyright law, which basically answers these issues. So, far as the copyright law is concerned, the copyright law under section 13 provides for certain subject matters of the copyright, which are mentioned here, and under section 14 it provides for rights of the copyright holders, rights of the copyright holder. Section 51 provides the acts which will constitute infringement. So, there are a lot of things which will constitute infringement. So, when it comes to infringement, I told you that copying in the physical form definitely constitute infringement, but copying in virtual space equally constitutes the infringement. Even in the virtual space, if anybody copies, stores, uploads any content and downloads any content and saves it in his or her computer, it amounts to copyright infringement. And internet is such a vast medium where lot of content is uploaded, downloaded, made available, disseminated, issued to the public, communications are being made to the public through internet. So copyright is one particular law which is handy or which is required for the purposes of regulating the infringement issues on copyright, and answer lies in section 51 of the Copyright Act itself, right, wherein it is clearly written that any such unauthorized use of a copyrighted content will amount to copyright infringement, and there is no demarcation in physical or virtual violation. So any violation even on the virtual space or in the cyber space through internet will tend to amount to copyright infringement, and some intermediaries who host third party content on internet, they may also be made liable if they are at fault. Generally they have a safe harbor under section 79 of the IT Act. Generally they have a safe harbor under section 79 of the IT Act, but this safe harbor or this exemption from any liability are not absolute. They have exemptions, but these are not absolute exemptions, or they do not have a blanket immunity. They may also be made liable in cases if they are at fault, or in cases if they do not apply the due diligence, required due diligence, if they become themselves the choosers of what to be shared and what not to be shared, if they themselves start intervening into or deciding on the modification of the content being shared or disseminated, etc. So in those cases intermediaries may also be made liable who are essential and integral part of the internet or functioning of the internet. So this is something very important, that copyright law has some provisions which cater to internet and which regulate the or may be used to regulate the internet in a very efficient manner. Now I will wipe it because there are certain points which I have brought for you to have a look at, which will make it more comprehensible for you to understand it, right. So online copyright infringement has gained the attention of the media most recently due to the piracy of movies and unauthorized distribution of such movies online. With the advent of MPEG 5 technology, online movie piracy is becoming more and more common, right. Then assuming that the subject matter is eligible for copyright protection involves two general requirements. We all IP scholars understand it, that fixation is one and requirement of originality is another for any work to get the copyright protection, right. And further it reads that establishing a prima facie case of copyright infringement requires only that the plaintiff prove ownership of a valid copyright and copying by the defendant, right. In this context, copying is shortened for the infringing of any of the copyright owner's exclusive right, right. So if anybody who is willing to institute the legal action under the copyright law, what is required for him to prove? He just need to prove that he owns the copyright, and he just required to prove that there has taken place a copying of his work on internet. Then he can easily assert his claim and you may say ensure or enforce his copyright over a particular work or over a particular subject matter, right. Then we come to next law that also is very important and plays a very significant role in regulating internet. This is competition law. It is also called antitrust law, right. What is the purpose and purport of competition law? Well, viewers, competition law is a law which is meant to increase the competition, which is meant to basically promote the competition in the marketplace by restricting anti-competitive practices, by restricting market dominance by the dominant players, by restricting anti-competitive behavior of the multinational companies, or for that matter national companies, resulting into or by collaborating into form of mergers or collaborations or amalgamations, right. So, this law also regulates the internet and helps to regulate the internet in a very efficient manner. Instance of antitrust concerns on internet involve issues of private data as commercialized commodity. We all know that private data is a new oil for the companies these days, and they take it as a commodity, they deem it as a commodity, and the fallout on competition and consumer welfare is very apparent on the internet, especially when the data is taken away from the users without their consent and is processed beyond their imagination or beyond the stipulated terms and conditions. This in turn is due to our increasing dependence on companies specializing in big data capabilities like WhatsApp. We all use WhatsApp very rampantly, and we know that we share a lot of detail with the WhatsApp, and our communication, though encrypted, but how this encrypted communication is used and processed, and to what extent it is really encrypted and it is not decrypted, we can't comment on that, because we all know that these companies basically have the big data capabilities. They may use it for any purpose, though they mention that they don't use it for the purposes beyond what are stipulated into their terms and conditions. But these days these antitrust issues are occurring and coming, because these companies at times opt some anti-competitive practices to take our data, to take information from us in an unscrupulous manner, and at times they also in the practice of or in the attempt to make their mark in the market, sideline small players, right, by coming out with such stringent or some such standards which will not let small players to operate freely in the market, right. So, big data capabilities or companies owning big data capabilities will always remain dominant, though antitrust issue will arise only when they abuse that dominant position. Otherwise, it is okay if they remain dominant, but the moment they abuse their dominant position, it becomes an antitrust issue, and the competition law immediately comes into rescue, or you may say immediately may be attracted, right. Then there are certain cases. This is a case of 2021 of the Competition Commission of India. Suo motu cognizance was taken, and investigations were started in the unilateral change in data privacy law of WhatsApp for potential abuse of dominance, right. So, we all know that there may occur some antitrust issues, and that is why our commission immediately took the suo motu cognizance in the change of the WhatsApp privacy policy, because they apprehended that it may result into potential abuse of the dominant position by the WhatsApp, and phone numbers and other information of lot of people or users of these platforms have been put in the recent past on sale by the hackers or by the hacker, right. National laws protecting the privacy of consumers in an age where multinational big data company mergers are not within the boundaries of domestic laws will not be adequate to ensure fair play in this institution. So, it is a concern that national laws which protect the privacy of consumers, especially in the age of big data company and their mergers, right, which is attracting competition law or antitrust law, right. Mergers of these companies, recent merger of WhatsApp of Facebook with Facebook, it is clear through such mergers which are between the big companies that our local laws or our traditional conventional laws will not be adequate to ensure fair play in this particular market, right, or in this particular relevant market. So, data should be a subject matter under the purview of consumer protection laws or antitrust legislation. It is to be decided, because if you apply the consumer protection law, definitely a consumer who is at detriment may get some relief, right, but when antitrust legislation is attracted or invoked, it brings in the advantage for the masses or for the entire public, or for the whole community, or at you may say whole country as such. Right. There are concerns relating to abuse of dominant position, dominant player having immense amount of data, etc. And there are a lot of anti-competitive practices on internet which these dominant players are exercising these days, and they are causing lot of damage to the relevant markets, which results as a corollary to what? To the dominance of one particular entity in the market, which results as a corollary into low competition in the marketplace, and at the end of the day it results to the consumer detriment, right, because the consumer will not have differential choices, will not have differential pricing, they will have to rely solely on one dominant player in the market because of their anti-competitive practices, right, and they at times collude. So, as I told you that big data companies, or especially companies having the capacity to to enter into or delve into the data, they at times collude, come together, and they try to preclude the entry of the newcomers into the market, right. So, all these things are competition concerns, or you may say all these issues are pertaining to the competition. So, competition law is one such law which may be helpful or very helpful for the purposes of regulating the internet. So, let us understand data privacy, though it is a issue which have been covered by me separately in a very comprehensive manner in a separate lecture, but here the mention of it is required, because on internet we know that a lot of data is being shared by the users, and it is stored by the internet or by the companies or intermediaries, and why our data is is being taken away when we are just made as commodities, and our data is made a commodity, especially in the light of the fact that things like internet are free to use, right, but here when internet is free, you are the product, or your information is the product. So, what do they seek? They seek only information about you, or about your behavior, about your consumer behavior, etc., right, and they process that, and then they make lot of money, or they do business on the basis of that. So, let us start with the premise that at the outset the protection of privacy cannot be separated from technological development, as nowadays the possibility to intrude someone's privacy has increased due to development of science and technology, and on internet our data may very easily be intruded. Organizations manage large amount of customer data that could be in the form of customer expenditure patterns or customer health data, it may be in the form of projects executed for customers, it may be in the form of educational, banking data, etc. This data is a strategic business asset, as it can be used to provide further services to the customer, and the marketing strategies may be built upon on the basis of this data. Corporations could use this asset for cross selling and sharing it with their business partners. The importance of this strategic business asset can be gauged from the goldfish ruling, right. So, there is a lot of concern, or there are a lot of concerns or issues and challenges which are in the digital age. So, with the digital age or advent of the digital age, the problem has increased, because monitoring, surveillance has increased over the period of time, it has increased rapidly, and it has resulted into dehumanization of one's intimate information, one's private information, right, and there are a lot of things which are at risk because of digitization of everything, and digital asset or digital information is considered a digital gold which hold them, or by the institutions which hold them, it is considered a digital gold. It may be a financial information, public records, medical and health, etc., etc. So, there are a lot of challenges so far as digital mediums are concerned, and we see that because of rampant use of internet or this digital mediums, which are basically internet or laden by internet, or you may say enabled by internet, consumers can and do benefit from targeted product recommendations. However, they also can and do incur substantial monetary costs and losses and violation of their privacy, right. Further, there are invasive technological services which take away your information, which take away your your personal sensitive information, and search engines are also such which record your information, and the individuals are no more into the control of their privacy at all, right. I am skipping these because these have been covered by me in separate lecture specifically dedicated to the impact of the internet as impact of the digital age or on privacy. Now, there is another law, like we earlier discussed copyright law, and then subsequently we discussed the competition law. This is one more law which is handy, or which is very important to regulate the internet, that is Digital Personal Data Protection Act of 2023. It is a new law, and it offers very important things. This is a very encouraging law because it is a first ever privacy act, or a law which strikes a delicate balance between individual rights and the organization's legitimate data processing needs. We all know that organizations, especially those organizations which have their business models through internet, they require processing of the data. They can't function without the processing of the data, right. So, the law in front of you strikes a good balance on the one hand of the individual rights, and on the other hand on the legitimate data processing needs of the organizations. And the primary purpose of this law is to regulate the processing of digital personal data and respect individuals' right to protect the data, while recognizing the necessity of processing of such data for lawful purposes, right. The language employed in the act is very simple and straightforward, ensuring easy comprehension for all. Moreover, the act aimed to establish a comprehensive legal framework to govern digital personal data protection in India, right. So, this law is worded in a very simple manner, it is very straightforward, and it governed your digital personal data very well. Further, the act has some provisions which cover personal data in digital format, as well as that data which is non-digital but subsequently digitized, right. The provision applies to both the kinds of data, which is again a very unique feature about this law, that it applies to data which is digitized, also to the data which is non-digital but subsequently digitized, right. Then we see that this act has some more features, right. Let me quickly take you through to those features. The act protects digital personal data by providing for the following: the obligations of data fiduciaries for data processing. There are a lot of obligations on the data fiduciaries. Data fiduciaries are those organizations which take your data, or to whom you entrust your data in the fiduciary relationship with them. And the rights and duties of data principles are also very well explained in this act, and some financial penalties for breach of rights, duties and obligations are also explicitly mentioned in this act. The act also seeks to achieve the following: that it causes minimum disruption while ensuring necessary change in the way data fiduciaries process data. It enhances ease of living and ease of doing business. It enables India's digital economy and its innovation system, right. So, the law is very beautiful. It is based on some good principles, and some of them are mentioned here for your perusal, right. The first and the foremost is the principle of consent and lawful and transparent use of personal data. The principle of purpose limitation, where use of personal data only for the purpose specified at the time of obtaining consent of the data principle. So, no data fiduciary can use it beyond the particular stipulated purpose. There is a limitation on that. The principle of data minimization, wherein the idea is to to minimize the storage of the data or processing of the data only to the extent of a particular or specified reasons, right, or when it is really necessary for a specified purpose. The principle of data accuracy, the principle of storage, the principle of reasonable security, and so on and so forth, right. Further, the act has some other innovative features, like the act is concise and thorough, simple, accessible, rational and actionable law. It uses plain language, contains illustrations, it contains no provisos and have minimal cross referencing. So, this law is very beautiful to regulate the internet, especially the aspect of data privacy on internet, right. Well, it is gender neutral law as well, because it uses, or you may say it is a law which uses she instead of he, and this is perhaps the first time, or very rare, when we see the legislative language uses the gender she instead of he, right. I am skipping these because these are not so very important. Now, I am coming to this aspect, which is information security management system for data security. Well, this is also very important, that on internet your information must be managed very well, and there has to be some security management system in place. So, for that, that needs to be developed to assure complete data security in the internet medium or on internet. The essential components of an effective information security management system that form the building blocks of a complete data security system are risk management, security policy and security procedures, business continuity plan. Then there are some building blocks which are called 5 fair information practices, right, which are also necessary for the management of the information in an online medium. Notice and awareness, that the corporation should give customers clear and detailed details about the usage and the disclosure of data. There must be clear notice, and all the customers must be made aware that their data is going to be used in this and that manner. Choice and consent. Choice refers to the right of the customer to request restrictions on the uses and disclosure of their data. Consent refers to receiving customers' permission before customer data is used and disclosed. So, these are building blocks on which the information management should happen, right. Access, this refers to customers' right to use their data. Customers should be able to see and get copies of their records and request amendments. Accountability, enforcement and recourse, organization should be held accountable for the customer data that they possess and for establishing mechanisms that will ensure compliance to policies and procedures. Organization should provide for reasonable methods to resolve disputes relating to the use of the data. Then data security and integrity, this refers to the data privacy assurance principle, stating that gathered customer data to the extent necessary would be complete, current and accurate. So, these 5 building blocks are very important for the management of your information in an online medium, and once they are in place, I am pretty sure that your data will remain in the safe hands, and it shall be processed only with your consent, and you shall be notified if there will be change in, or there will be amendment into processing of your data in any manner whatsoever. Well, going ahead with another important development in the regulatory framework relating to internet, we have intermediary guidelines and digital media ethics code of 2021, and these guidelines we all know were brought by the Ministry of Electronics and Information Technology, and these guidelines were brought in response to the growing criticism against the government. While it recognizes the right to criticize and disagree, right, it aims to provide a robust complaint mechanism for social media and OTT platforms. So, these guidelines were brought basically to give robust complaint mechanism against social media and OTT platforms, because there were a lot of grievances of the people against these platforms, be it a social media or a OTT platform. And in fact, before 2011, the mechanism to complain against the social media and OTT platforms were inexistent, but now with the 2021 guidelines, we have the mechanism to complain against the social media and OTT platforms, and these rules have been in light of the recent rundown on the OTT platforms by the government, which have been actively, rather vehemently lobbying for stronger and more stringent regulations in place. However, contrary to such view, as per the PIB, the rules have been formulated keeping in mind the importance of free speech and journalistic and creative freedoms. Regardless of the political connotations, the enactment of these rules puts India at par with international regime on digital medium regulation, providing a more comprehensive and holistic protection to its user. So, by bringing those rules, we have come at par with international regimes. in our attempt to address the digital media regulations and to provide a holistic protection to the users of the internet or of the social media. These general guidelines extend their scope over all intermediaries, including social media as well as significant social media intermediaries. So, these guidelines have also distinguished between social media intermediaries and significant social media intermediaries. Significant social media intermediaries are those which have a stipulated minimum number of users or subscribers. I think so far as I recall correctly, the significant social media must have at least 5 lakh subscribers. If any social media platform having less than 5 lakh subscribers, it is a mere social media intermediary, it is not a significant social media intermediary. The underlying thread that binds the whole rules together is the code of ethics mentioned in the appendix, and these rules applies even to news and current affairs, even to online curated content and on advertisements too. So, in an online manner on internet, all these things, be it a news reporting or current affairs or online curated content or for that matter advertisements, are very rampant, right. These rules have some very striking features, like it has a clause on due diligence. Rule 4 of these rules enlists certain due diligence obligations for an intermediary. In fact, I will say that these rules have brought wider obligations and responsibilities of the intermediaries, which include the duty to publish their rules and regulation, privacy policies and user agreements for access either on its websites to allow its users to access the same. The material so published must crystallize the user's responsibility not to host, display, upload, modify, transmit, store, update any form of information which belong to another person, is defamatory, is dangerous to minors, is resulting in infringement of any intellectual property right, is deceiving or misleading, is impersonates another person, hampers the integrity, defense, security or sovereignty of the country or friendly relations of the state, right. These are reasonable restrictions of provided under the Constitution, Article 19 of the Constitution of the India, and any such information which contains any software, virus or any program designed to corrupt or interrupt the functionality or is patently false and untrue. So, any internet intermediary, be it a social media intermediary or a significant social media intermediary, they can't host, display, upload any information which falls in this particular category, which belongs to another person. Without the concept of another person, they cannot host or upload that information, which is defamatory, which is dangerous, which is resulting in infringement, etc. They have to apply the due diligence. If they do not apply the due diligence, then they may also be made contributory infringers, or they may be also made liable or accountable for secondary infringement or secondary violation of any of these things, right. There are a couple of more things which are very noticeable and remarkable about these rules, that there is a provision of notification to the user. The users are provided with the notifications very often as per these rules, and as per these rules within 36 hours the intermediary is obligated to remove or restrict access to any wrong information. And there are a couple of more things where enforcement has been made by the intermediaries very expeditious, right. Then there are additional compliance measures for the significant social media intermediaries. So, they have more onus, or they have been made onerous to comply few more things besides the things which we discussed in the previous slide. Specifically under rule 5.6, if we see, in order to facilitate the processing of complaints with respect to violations mentioned, an appropriate mechanism shall be developed by the significant social media intermediary. In such a process, the intermediary must notify the complainant of the extent of action taken. And another important thing under rule 5.2, that the significant social media intermediary may also be obligated to tell the first originator. This resulted into a controversy, if you remember, in 2021 when these rules were brought. and WhatsApp is an encrypted messaging services. So, WhatsApp is a significant social media intermediary. So, they according to this rule are obligated to even tell the first originator, but they initially responded that they won't do it, because if they tell, or if they disclose the first originator of a particular message, it means they are not providing the encrypted services. That is why they went to the court, and ultimately some exemptions were created for such significant social media intermediaries. But if they are at fault, then they will have to necessarily be made liable for such things. Then some special measures for sexual offences, for verification of users, for removal of information, etc., and some safeguard measures for online media, grievance mechanism has been strengthened, right, and so on and so forth. So, I will not cover all these, but definitely these intermediary rules of 2021 are very significant rules for addressing issues arising on internet, specifically because of the involvement of the intermediaries, right, or significant social media intermediaries. Now, let us have a quick look at the cyber laws prevailing in other countries. In European Union, there are many cyber laws, or cyber legislative responses, I mean, or regulatory responses, like Cyber Resilience Act, then the Cyber Solidarity Act, EU Policy on Cyber Defence, the EU Network and Information Security Directive, the ENISA, that is European Union Agency for Cyber Security. It provides for support to EU member states, etc., and establishes a cyber security certification framework for products and services, and creates and outlines best practices for cyber security and laying out steps against ransomware, promotes cyber resilience, increases operational cooperation to help EU member states with handling cyber security incidents, and support the coordination of the EU in case of major cross border cyber attacks and cyber security issues. These are some of the responses apart from this very important response, that is GDPR, which was introduced and passed in 2016 and made operational in May 2018. This regulation is one of the most crucial and far reaching legislative pieces for organizations operating within the EU, and this GDPR has a task and obligation concerning data privacy, cyber security and breach management. It aims to standardize data protection regulation in the EU. It aims to protect personal data and privacy for EU citizens. It aims to simplify regulation processes for international organizations. Additionally, it aims to encourage controllers and processors to follow relevant protocols, implement data privacy measures, and ensures that data is collected with consent before becoming publicly available. Right. So, the EU cyber security strategy is very robust. In 2020, in order to strengthen cyber security, the EC and High Representative of the Union of Foreign Affairs and Security Policy from the European External Action Service presented and adopted a new EU cyber security strategy, which you may read and refer to understand it more. Right. Then they have Cyber Security Act introduced in June 2019. Right, which also strengthen the role of ENISA, and it builds trust, etc., etc. The EU has a wide cyber security certification scheme as well in place. Now, let us have a look at cyber security laws in US. Well, in US there are no single federal law, or there is no single federal law, rather they have several states, and they have several laws prevailing in several states. The US is following laws and directives and regulations like SEC regulation, then they have GLBA, that is Graham-Leach-Bley Act, which is the most important over there. Then they have it is a quick reference to these laws, you may refer to these, Federal Trade Commission Act, and further they have HIPAA, Health Insurance Portability and Accountability Act. So, they have a sectoral regulation to govern internet. They do not have one particular set of regulation to govern the internet. They have rather sectoral regulations, right. In different sectors they have different laws, Children Online Privacy Protection Act, etc., right. Then they have ECPA and SCA, Electronic Communications Privacy Act, and they have EPA, Privacy Act of 1974, Consumer Privacy Protection Act of 2017, important judgments are also which also make a part of this whole regulatory framework, and which are valid jurisprudence to understand the law relating to internet. And we have some cases here. I have mentioned some cases which are Indian cases: Anuradha Bhasin versus Union of India, Internet and Mobile Association of India versus Reserve Bank of India, Google India Private Limited versus Vishakha Industries, Society of Composers, Supreme Court case, Satyam Infoway versus Sifinet Solutions. Shreya Singhal is one of the leading judgments on internet medium, or you may say on freedom of expression and speech. Swapnil Tripathi and others versus Supreme Court of India. This Satyam Infoway is also very important to understand trademark issues. Internet and Mobile Association is there. Google India Private Limited is also there to understand jurisdictional issues in the cyberspace, right. So these are the cases. Now I will conclude my lecture by just telling you that cybersecurity has evolved beyond its traditional focus on personal data protection and cybercrime, extending its influence across the realms of politics, economics and national security. Policymakers are increasingly focused on cybersecurity, and this medium is multifaceted and it is evolving every day. So should be the legislative response, right. The internet is a vast new marketplace and arena for political discourse. Its inherently global character and low barriers to entry facilitate participation by many individuals, small enterprises and so on and so forth. The characteristics are changing the political dynamics of international law format and enforcement. The internet also invites new forms of regulation. This is you may say is a continual process, right. The law should also continually evolve with the challenges posed or with the developments taking place in the internet medium, and there can be no one particular omnibus, there can be no omnibus legislation to cater to the internet, or you may say to address the issues on the internet. There are several legislations which come together along with the jurisprudence and guidelines which cater to the internet, right. So with this I take your leave, and I will meet you again with another interesting lecture in this series called Law, Science and Technology. Thank you very much.